separate and distinct, we have decided to exercise our discretionary power to quash by certiorari, having regard to the peculiar circumstances of each ruling. Consequently, we hereby quash the orders of mandamus made for collation of results by the Electoral Commission in the following constituencies: 1. Okaikwei Central, 2. Ablekuma North, 3. Tema Central, and 4. Techiman South. Accordingly, the collation of results in the above constituencies by the Electoral Commission after 20th December 2024 on the orders of the court are hereby set aside. For the avoidance of doubt, the orders of the High Court made in respect of Nsawam Aduajiri and Hafuanon North are not affected by this order, by this our order. And
okay, so currently, this is definitely a good news for the National Democratic Congress. We told you yesterday, say, what is going on? We are anticipating, say, whatever a year in summer court, a year NDC for the court to Supreme Court anymore. Based on the Re-collation, of course, so they lost almost all the 7 seats. Information about and signing pay yesterday what we report. We're telling you, say, based on NDC for almost submission at the Supreme Court, it is likely, say, the NDC is going to win this particular case. And today, why? The reason why this particular thing did happen is all because of a certain law, CI 127. All because of the law CI 127. It is the law. And the NDC for a law NDC for a okay. We see 2020 you amended the law. You brought out CI 127. If you brought out CI 127, now CI 127, the law states clearly say you cannot declare any results. So you cannot do any re-collation after the results have been made public. If you announce the results fake and you announce no more re-collation. But would you want my exception to the rule? So okay, I'm easy. Me and I'm rule. I can make an exception. And even though you've declared results, you came back, did re-collation, and then subsequently all the seats are going in for the the New Patriotic Party. Based on this, NDC for the kind of file a injunction at High Court, which was squashed. But when they got to Supreme Court in Supreme Court, based on all the aforementioned, now let's put this on the screen so you can know exactly where we are heading. More videos are there, but I just want to break it down for you. We'll share in some joinings for post Re-collation. Supreme Court's quashes results in Tema Central, Ablekuma North, Techiman South, and Okaikwei Central. So basically, what we are learning currently, Supreme Court based on all that aforementioned, no. In some NDC for the other say results na ekoye no omo na sabi omu di nkunim e na EC aye re-collation na EC embra na nkasa CI 127 e kire say announce results on team re-collation inti pe EC on nkasa na embra no EC is wrong and Supreme Court say inkofu asema mu kenye tough pa o. So Supreme Court today, if you following the updates, Supreme Court today sat for a very long time. They sat for a very long time. A whole and MPP for omo lawyers, which is led by Nimako, any other people. They came out and say law. They came out and say court, Supreme Court already squashed the beef and has squashed the argument by the National Democratic Congress. It besides said there, and also it's because of the seat. Certiorari. Forgive me, certiorari. Now you can't law term certiorari a rates and now order. If he a court and a lower court now certiorari no, according to what we are learning currently no, so what court, high court, now high court ediasem na akwa against no the court to Supreme Court e was all the high court judgment no o file was all the high court judgment e ka ho any for the certiorari a law term. But NDC MPP for ne ka say essence NDC for no anfa anka ho nti no any sisi ano based on that no based on this particular certiorari, yen dismissal case, and the High Court said even though NDC for lawyers they failed to do it, that we can't base on that particular grounds. I can say certiorari, we are basing on that, yes, squashy case, Into you say okay, if that is the case, then it means say issue na ekoso ni nyina no yenya green light ye de certiorari na to screen so ye man nye kese. So as you can see, also certiorari, a writ or order by which a higher court reviews a case tried by a lower court. So basically, because of the missing certiorari, now MPP for pushes say yen dismissal case, even based on merits, a whole and a court said your argument is valid, but we will hold. And now, even though the NDC for lawyers, so your mind, but will not based on that grounds to dismiss the case. Shall say the Supreme Court has quashed results in the re-collation of votes. Tema Central, Ablekuma North, Techiman South, Okaikwei Central, in the 2024 parliamentary elections. The Apex Court added that the order does not affect Ahafo North and Isawam Adweji. Why? Because those places, they did not announce the result before the re-collation. And they didn't announce the result before the re-collation. It's basically, omo announce here and then no, because CI 127 they say you can't announce any results after you can't do a re-collation after you announce results. So basically, omo your re-collation, they didn't announce the results. As I said, so we understand. Also, to us who are say. According to the court, the trial judge violated the right to a hearing of the NDC parliamentary candidates when they appealed the High Court. So basically, sisi an nsema court party say sa first judge na odi asem no of violate because when ti asem no po allow my NDC form arguments amba was squash easy, go and do your work, go and do re-collation. And a Supreme Court judges based on all of these aforementioned, trial courts now or DSM or High Court, he has done a big mistake. He was not fair. In fact, certain videos are now trending on social media. We even do we saw say the Supreme Court judge, they were scolding the trial and another High Court judge or master ruling and say, master, based on all of this ruling, based on all of this is a work on, you did not follow the due process. Orion or Sanso Trust say, shall say, the Supreme Court has squashed and nobody a candidate. But Oba Siena, or say the other decision goes directly against a controversial re-collation undertaken by the Electoral Commission and subsequent declaration for the said constituency. So, this particular law, what is really happening is the EC, okay, the EC now, onto me and Bambe, any re-collation bill. Because already you say brand as CI 127 your own law no chese untimi re-collation. It's why a re-collation after you've announced results then it means a void. Into any re-collation that comes afterwards, a void. This is a big victory to the National Democratic Congress. Shall I say, also he added that despite squashing the application of mandamus remains alive and has to be heard and determined by the High Court on Tuesday, December 31st. The NDC also accused the High Court trial judge who ordered the EC to recollect results in the disputed constituencies of being biased and having procedural errors. Which many of us have raised this concern because among forecast that particular trial judge he was appointed by Akufo-Addo. And currently, the NDC says that particular trial judge, he has violated the rules and regulation. That is it. Yes, and to us be has say, mame. Or say, the now squashed December 20th ruling had directed the EC to recollect results in 9 constituencies where irregularities were alleged. The decision followed a mandamus application filed by New Patriotic Party parliamentary candidates who argued that discrepancies in the tabulated results required verification to uphold transparency and accuracy. But the EC has since complied with the order in 7 constituencies, but re-collation Domi Kwabenya and Ablekuma North remains incomplete. So basically, based on all of this, it is a step in the right direction. So the National Democratic Congress arguments to a moment is simple. EC, who see re-collation after they've announced results. No re-collation. Me boy results now. No re-collation. As I say, Akwese, Yabo Boye, na yashe niyama final scores. after they also some be man difference so they be you announce the results maybe ultimately some ban be ka say yenko review go no they be any possible they be wow when I will see I-127 now amend the law in 2020 that is what it said so NDC4 they are just going by the playbook and the playbook no actually said the National Democratic Congress so far they are doing well and they are on their path to retain almost most of the seats lost but exception here in Saoma Duaji I think I have for North or Bono North or something. But those other constituencies now you declare winners so Okaikwei North and so on there. Currently, no Baba Sadiq Munia they can start having another champagne and a victory lap. Meanwhile, you could see more things that a pop up, a brad trial judge, a brad Supreme Court sitting in there, explaining why they came to this particular conclusion in their declaration. Say EC should squash all of those recollated results.
Since the orders which have been brought to be quashed are separate and distinct, we have decided
by the NDC.
Yes, you make the point and let's see if it will help us locate.
Okay. My Lord, in the said exhibit, the applicants had applied for judicial review, whereupon they have indicated that there have been declarations in their favor with video evidence of those declarations. With video evidence of those declarations.
Yeah, but those were not before the judge who determined the mandate.
They were before him. My Lord, they were before him. Yes. I stood up. Yes, my Lord. That's the unique thing. I stood up and brought to his attention that, my Lord, pending before you is this application. So we even filed ours on the 16th. On the 16th of December. This mandamus application was filed on the 17th. But my Lord chose to hear the mandamus that was filed on the 17th. Yes. It was in the court and before him.
Please, the two are not the same. Okay. Was it pending in that court or it was right before him?
My Lord, it was pending.
Say so.
And it was hearing that same day.
Or it was listed for hearing?
Yes, that same day. So I stood on my feet and drew my Lord's attention. But my Lord, these are declarations with video evidence. So consider my application first. He ignored it.
I lost respect.
Yes,
you see, some of the facts being heard on this court are indeed erroneous. They are erroneous. And I think it's fair that I put them in context. Okay. The process he found.
Counsel, you can read.
No, just hold on.
Please. What he found was not before the judge. It was not before the judge.
No, it may not be on that docket.
Was listed.
It may not be on that docket, but it may be in a separate docket.
No, he came to court holding the documents.
No, we're talking about the second application. Or the first application, the one they filed on 6.
The one they filed.
The first application. Okay. So, Mr. Tamaklo,
yes.
Continue.
So, my Lord, at the time my Lord considered, he had before him video evidence. And in fact, when I brought it to the attention of my Lord, he indicated in open court that the docket was just brought to him the evening. And in fact, that application, I moved it together with my learned senior. After he had granted the mandamus application, he now asked me to call that.
Oh, okay. So he heard it?
Yes. In fact, I even made a prayer that, my Lord, I beg you, watch the videos. He said he will do it and started giving his ruling.